Welcome back. Bail, not jail. That's the precedent that has been set up by the Supreme Court of India a very, very long time ago. Now, beyond the wordplay, it's a very important legal message. It means that getting bail to the accused must be the norm and that jail should be the exception. The Supreme Court of India has emphasized this point not just through many, many years, but throughout this year as well. The question is, are the lower courts hearing? Even today, Chief Justice of India, D.Y. Chandrachud, talked about the trend of denying under trials bail. He was speaking at an event in Andhra Pradesh. Let me quote what he has said. He says, the number of under trials languishing in prisons in India reflects a paradoxical situation. Deprivation of liberty, even for a single day, is a day too many. Justice Chandrachud goes on to say that bail must not become a meaningless and mechanical procedure. But looking at some of the recent cases, that's exactly what is happening. Applying for bail in lower courts is mechanical. You get rejected and then apply to higher courts. It's only at the higher court or the Supreme Court that there is a real inspection of the bail application. The question is why? The Chief Justice of India himself gave some answers today. He believes there is an element of fear amongst judges in the district courts, a fear of perception. If they grant bail now, how will it be perceived by the higher courts? Justice Chandrachud is saying that this fear is rational but must be worked upon. If you look at some of the high-profile cases, in fact, recently, lower courts have repeatedly refused to grant bail. For example, take Father Stan Swami, for example. He was repeatedly denied bail, even on medical grounds. He ended up dying in custody last year. Another example is Siddique Kappan, the journalist from Kerala. He was arrested in 2020 and repeatedly denied bail by the lower courts. It was the Supreme Court that finally gave him bail in a terrorism case, alleged terrorism case. Now, you may also remember the arrest of Shiv Sena leader Sanjay Raut. He spent around 100 days in custody and was given bail by a PMLA court. The judges called the arrest illegal. Another example from Maharashtra is former Home Minister Anil Deshmukh. He spent almost 1 year in jail before the Bombay High Court granted him bail. Omar Khalid, similar story. He was arrested in 2020 and slapped with terror charges. We are set to enter 2023. 2020 and now 2023, 3 years. But he is yet to be granted bail. These are just some of the high-profile cases of jail, not bail. The truth is, India's prisons are packed with under trials. Around 77% of prisoners in the system are awaiting trial. So there is a wide gap between what the Supreme Court is saying and what the lower courts are actually doing. And stuck in this wide gap are thousands and lakhs of prisoners who are losing valuable time in their life. Why is that happening? That's the question I'm asking my guests this evening. Ashwani Kumar Dubey is an advocate from the Supreme Court joining us. Aditya Singh is an advocate, again, joining us on the broadcast. Thank you both very much. Aditya Singh, I'm coming to you first. Why is bail, not jail, just a great-looking rule only on paper?
Okay. Well, see, it is a time-honored principle of jurisprudence that bail is the norm, jail is the exception. Of course, in the contemporary era, the courts have tend to, increase the stringency because our country has of late seen a lot of economic offenses, where the money trail has to be established. So I do feel that when we see a whole list of cases in the recent times, it appears that in some cases, not all, like certain cases, for example, be the Sanjay Raut matter or some matters where there are financial offenses involved, then of course one needs to certainly, custodial interrogation may be required. But of course, the objective of bail is to assist the doctrine of custodial interrogation. However, we have seen innumerable cases. For example, there are quite a few cases in which I myself have appeared, like in the case of Mangle and others, where despite, because like the biggest concern is that, in some cases, bail is not granted even where the matter appears to be a complete, abuse of process of law. I do feel that the doctrine of bail, not jail, is a very time-honored doctrine. And, it has contemporary relevance because the court has to essentially see whether the person will interfere with the investigation or not. So it is something And when we look at the recent cases, be it Father Stan Swami and all, one can opine that probably, considering the age of the person, etc., the doctrine of bail, not jail, should have been followed. In fact, what I've seen is that the judges are taking a lot more contemporary approach, and they are judging bail applications in the right of, like for instance, I was in the Bombay High Court the other day, and I observed that in a case of environmental offense under the Environment Protection Act, pollution, anticipatory bail application was rejected. So I do feel that yes, bail, like, because when our criminal justice system takes such a long time to do trial, at least then the bail during the duration of trial can consider to be granted, if not at the stage of investigation. So I do feel that this doctrine is relevant, and it can be applied properly also even in the contemporary era.
Okay, Ashwani Kumar Dubey, the Chief Justice of India is saying this, I'm not saying this, that the lower courts are scared. They are scared of what the perception will be if they start granting too many people bail too quickly. What are they scared of? If it's the basic of law, bail not jail, what are they scared of?
See, there is admittedly that the jurisprudence, the criminal jurisprudence says that the bail is a rule and jail is an exception. And there is no gainsaying that the bail should not be granted or rejected in a mechanical manner, as it concerns the liberty of a person. What happens, there are four kind of criminal cases are categorized. In a case where the offense is punishable with imprisonment of 7 years or less, then in that case, there is judgment of Arnesh Kumar, a leading judgment of Supreme Court, which says that without following the due procedure of law, without issuing notice, you will not arrest. The second category comes is the offenses punishable with death, imprisonment for life, or imprisonment for more than 7 years. In that case, it depends on the case-to-case basis. So for the principle, bail is a rule, jail is an exception, is equally does not apply because the court has to see the evidences. The third category is the offenses punishable under special acts, the special statutes passed by the parliament, vis-a-vis the NDPS Act, vis-a-vis PMLA, the UAPA, and the Companies Act, and the economic offenses not covered by the special act. So far as the first offense, first category is concerned, where the punishment is less than 7 years, the bail should be granted. In that case, arrest should not be made. Supreme Court is clear, and many investigating officers have been punished by the courts. The second is imprisonment of life or more than 7 years. The court evaluate the evidences. There is most of the trial courts also takes a decision, discretionary decision to grant the bail. But that depends actually on the base case to base. Third, so far as the NDPS PMLA cases are concerned, that cases are the offenses against the society, the drug menace, the UAPA, the other PMLA cases, the economic offenses. Here, the bail is not a rule. Here, the bail, first one has to prove that he is not involved in the proceeds of crime, because those cases are directly or indirectly interlinked the society as large. So the principle which has been set by the Justice Venkat Chalaya, the principle which Honorable Justice Chandrachud has today referred, is in fact with respect to the cases where under trial prisoners, the prisoners which are languishing in jail, in the absence of giving the adequate security, in the absence of not having the proper legal assistance, in the absence of the courts are overburdened. So Honorable Chief Justice of India has emphasized on that aspect, that look, here is the case where being the protector of the Constitution, being the protector of the fundamental rights of individual, we have to ensure that one should not languish in the jail. That is what the Supreme Court of India has said. And it's a jurisprudence, criminal jurisprudence. We also argue these points. But the case-to-case merits of the case, the matters related to that case, offense involved, gravity of the offense involved, nature of the offense, that must be looked into. Yeah, Shreya, over to you.
So, absolutely. So, what happens is, we often say, we often advocate for bail, not jail, and that is the right thing to do. But when you see a rapist walk out, or when you see a molester walk out, then you start questioning it. I think the Chief Justice of India is very clear that bail, not jail, is the basic of law, and it needs to be followed. After of all people in prison right now, 77% are under trials. And they can, many of them, I'm fairly certain, can be easily let off on bail. Instead, we are clogging the system. We are clogging the courts and we are clogging the prisons as well. We leave it there for the moment. Thank you very much, Ashwani Kumar, Dubey and Aditya Pratap for joining us on this very quick chat. Moving on, Brazil.